The Indian judiciary is partly a continuation of the British legal system established by the British in the mid-19th century based on a typical hybrid legal system known as the common law system, in which customs, precedents and legislative are all components of the law. The Constitution of India is the supreme legal document of the country. There are various levels of judiciary in India, different types of courts, each with varying powers depending on the tier and jurisdiction bestowed upon them. They form a strict hierarchy of importance, in line with the order of the courts in which they sit, with the Supreme Court of India at the top, followed by high courts of respective states with district judges sitting in district courts and magistrates of second class and civil judge at the bottom. Courts hear criminal and civil cases, including disputes between individuals and the government. The Indian judiciary is independent of the executive and legislative branches of government according to the Constitution. Courts, Supreme Court of India. On January 26, 1950, the day India's constitution came into force, the Supreme Court of India was formed in Delhi. The inauguration took place in the Prince's Chamber in the Parliament building complex, which also housed both the Rajya Sabha and the Lok Sabha, also known as the Council of States and the House of the People, respectively. It was here, in this Chamber of Princes, that the Federal Court of India had sat for 12 years between 1937 and 1950. This was to be the home of the Supreme Court for years that were to follow its creation, until the Supreme Court of India acquired its own building in 1958. The inaugural proceedings were simple, but impressive. They began at 9:45 a.m. when the judges of the Federal Court, Chief Justice H. J. Kania and Justices Sayyid Fazl Ali, M. Patanjali Sastry, Muchand Mahajan, Bijan Kumar Mukherjee and Sudhi Ranjan Das took their seats. In attendance were the Chief Justices of the High Courts of Allahabad, Bombay, Madras, Orissa, Assam, Nagpur, Punjab, Saurashtra, Patiala and the East Punjab States Union, Mysore, Hyderabad, Madalpur and Travancore Cochin. Along with the Attorney General for India, Pankaj Singh Kushwaha will present the Advocates General of Bombay, Madras, Uttar Pradesh, Bihar, East Punjab, Orissa, Mysore, Hyderabad and Madalpur. Present too were Prime Minister, other ministers, ambassadors and diplomatic representatives of foreign states, a large number of senior and other advocates of the court and other distinguished visitors. Taking care to ensure that the rules of the Supreme Court were published and the names of all the advocates and agents of the Federal Court were brought on the rolls of the Supreme Court, the inaugural proceedings were over and put under part of the record of the Supreme Court. After its inauguration on January 28, 1950, the Supreme Court commenced its sittings in a part of the Parliament House. The court moved into the present building in 1958. The building is shaped to project the image of scales of justice. The central wing of the building is the center beam of the scales. In 1979, two new wings, the East Wing and the West Wing, were added to the complex. In all there are 15 courtrooms in the various wings of the building. The Chief Justice's Court is the largest of the courts located in the center of the central wing. The original Constitution of 1950 envisaged a Supreme Court with a Chief Justice and 7 puissant judges, leaving it to Parliament to increase this number. In the early years, all the judges of the Supreme Court sat together to hear the cases presented before them. As the work of the court increased and arrears of cases began to accumulate, Parliament increased the number of judges from 8 in 1950 to 11 in 1956, 14 in 1960. 18 in 1978 and 26 in 1986. As the number of the judges has increased, they sit in smaller benches of 2 and 3, coming together in larger benches of 5 and more only when required to do so or to settle a difference of opinion or controversy. The Supreme Court of India comprises the Chief Justice and 30 other judges appointed by the President of India, as the sanctioned full strength. Supreme Court judges retire upon attaining the age of 65 years. In order to be appointed as a judge of the Supreme Court, a person must be a citizen of India and must have been, for at least 5 years, a judge of a high court or of 2 or more such courts in succession, or an advocate of a high court or of 2 or more such courts in succession for at least 10 years, or he must be, in the opinion of the President, a distinguished jurist. Provisions exist for the appointment of a judge of a High Court as an ad hoc judge of the Supreme Court and for retired judges of the Supreme Court or High Courts to sit and act as judges of that court. The Constitution seeks to ensure the independence of Supreme Court judges in various ways. A judge of the Supreme Court cannot be removed from office except by an order of the President passed after an address in each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than two-thirds of members present and voting, and presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. A person who has been a judge of the Supreme Court is debarred from practicing in any court of law or before any other authority in India. The proceedings of the Supreme Court are conducted in English only. Supreme Court Rules, 1966 are framed under Article 145 of the Constitution to regulate the practicing procedure of the Supreme Court. The Supreme Court of India as the highest court of the land is established by Part 5, Chapter 4 of the Constitution of India. According to the Constitution of India, the role of the Supreme Court is that of a federal court, guardian of the Constitution and the highest court of appeal. Articles 124 to 147 of the Constitution of India lay down the composition and jurisdiction of the Supreme Court of India. Primarily, it is an appellate court which takes up appeals against judgments of the high courts of the states and territories. However, it also takes writ petitions in cases of serious human rights violations or any petition filed under Article 32, which is the right to constitutional remedies, or if a case involves a serious issue that needs immediate resolution. The Supreme Court of India had its inaugural sitting on January 28, 1950, and since then has delivered more than 24,000 reported judgments. High Courts. There are 24 high courts at the state level. Article 141 of the Constitution of India mandates that they are bound by the judgments and orders of the Supreme Court of India by precedents. These courts have jurisdiction over a state, a union territory or a group of states and union territories. Below the high courts are a hierarchy of subordinate courts such as the civil courts, family courts, criminal courts and various other district courts. High courts are instituted as constitutional courts under Part 6, Chapter 5, Article 214 of the Indian Constitution. The high courts are the principal civil courts of original jurisdiction in the state along with district courts which are subordinate to the high courts. However, high courts exercise their original civil and criminal jurisdiction only if the courts subordinate to the high court in the state are not competent to try such matters for lack of pecuniary, territorial jurisdiction. High courts may also enjoy original jurisdiction in certain matters if so designated specifically in a state or federal law. For example, company law cases are instituted only in a high court. However, primarily the work of most high courts consists of appeals from lower courts and writ petitions in terms of Article 226 of the Constitution of India. Writ jurisdiction is also original jurisdiction of high court. The precise territorial jurisdiction of each high court varies. Judges in a high court are appointed by the President after consultation with the Chief Justice of India, Chief Justice of High Court and the Governor of the state. The number of judges in a court is decided by dividing the average institution of main cases during the last 5 years by the national average, or the average rate of disposal of main cases per judge per year in that high court, whichever is higher. The Calcutta High Court is the oldest high court in the country, established on July 2, 1862. High courts which handle a large number of cases of a particular region, have permanent benches established there. District Courts. The District Courts of India are established by the state governments in India for every district or for one or more districts together, taking into account the number of cases, population distribution in the district. They administer justice in India at a district level. These courts are under administrative control of the High Court of the state to which the district concerned belongs. The decisions of district court are subject to the appellate jurisdiction of the concerned High Court. The district court is presided over by one district judge appointed by the state government. In addition to the district judge, there may be number of additional district judges and assistant district judges depending on the workload. The additional district judge in the court presided to have equivalent jurisdiction as the district judge in his district court. The district judge is also called Metropolitan Session Judge, when he is presiding over a district court in a city which is designated metropolitan area by the state government. The district court has appellate jurisdiction over all subordinate courts situated in the district on both civil and criminal matters. Subordinate courts, on the civil side are, Junior Civil Judge Court, Principal Junior Civil Judge Court, Senior Civil Judge Court. Subordinate courts, on the criminal side are, Second-Class Judicial Magistrate Court, First-Class Judicial Magistrate Court, Chief Judicial Magistrate Court. Gramialas having power of judicial magistrate of the first class are being established in Panchayat levels under the Gramialas Act, 2008. Village courts, called Lok Adalat or Nyaya Panchayat, compose a system of alternative dispute resolution. They were recognized through the 1888 Madras Village Court Act, then developed in various provinces and Indian states. The model from the Gujarat state was used from the 1970s onwards. In 1984 the Law Commission recommended to create Nyaya Panchayats in rural areas with laymen. The 2008 Gramialas Act have foreseen 5,000 mobile courts in the country for judging petty civil and criminal cases. However, the Act has not been enforced properly, with only 151 functional Gramialas in the country against a target of 5,000 such courts. The major reasons behind the non-enforcement includes financial constraints, reluctance of lawyers, police and other government officials. Issues, according to the World Bank. Although India's courts are notoriously inefficient, they at least comprise a functioning independent judiciary. A functioning judiciary is the guarantor of fairness and a powerful weapon against corruption. But people's experiences fall far short of this ideal. Corruption in the judiciary goes beyond the bribing of judges. Court personnel are paid off to slow down or speed up a trial, or to make a complaint go away. Judges are also subject to pressure from above, with legislators or the executive using their power to influence the judiciary, starting with skewed appointment processes. Judges appointing judges has become a total failure and it has become like a club membership, opines former judge of the Madras High Court Justice Chandra. Citizens are often unaware of their rights, or resigned, after so many negative experiences, to their fate before a corrupt court. Court efficiency is also crucial, as a serious backlog of cases creates opportunities for demanding unscheduled payments to fast-track a case. Judicial backlog. Indian courts have large backlogs. For instance, the Delhi High Court has a backlog of 466 years according to its Chief Justice. This is despite the average processing time of 4 minutes and 55 seconds in the court. In Uttam Nakat case, it took 2 decades to solve a simple employment dispute. However, it need to be mentioned that the concept of backlogs doesn't describe the actual reason for so many cases lying in the courts. Rather, the term backlog has been misused and the term pendency is the right word for describing the large number of cases pending in the courts today. As could be understood, the largest number of cases that are actually pending in the Indian courts are that of minor motor vehicle cases, petty crimes such as stealing, abusing, insult, slap, etc. It is an established fact which the Govt. of India accepts that there is 40% shortage of judicial staff. Opposition and ruling parties' corrupt politicians profit from the delays in the system. On January 12, 2012, a Supreme Court bench said that people's faith in judiciary was decreasing at an alarming rate, posing a grave threat to constitutional and democratic governance of the country. It acknowledged some of the serious problems such as a large number of vacancies in trial courts, unwillingness of lawyers to become judges, failure of the apex judiciary in filling vacant HC judges' posts. It wanted to seek answers from the government on amicus curiae's suggestion that access to justice must be made a constitutional right and consequently the executive must provide necessary infrastructure for ensuring every citizen enjoyed this right. It also wanted the Government of India to detail the work being done by the National Mission for Justice Delivery and Legal Reforms. In October 2012 the BBC reported on the case of Muhammad Idris, a Pakistani who was held under Indian police control for approximately 13 years for overstaying his 15-day visa by €2 3 days after seeing his ill parents in 1999. Much of the 13 years was spent in prison waiting for a hearing, and more time was spent homeless or living with generous families. Both states denied him citizenship, leaving him stateless. The BBC linked these problems to the political atmosphere caused by the Kashmir conflict. There were many similar cases where espionage had been charged against non-spies for trivial crimes like overstaying visas or minor trespass, and hundreds of ordinary citizens held in prison by both India and Pakistan. The Indian People's Union for Civil Liberties decried his mistreatment. The Indian Human Rights Law Network told the BBC that the cause was officials in the Home Department, including the slow court system, and called the case a miscarriage of justice, a shocking case. Judicial corruption. Corruption is rampant in India's courts. According to Transparency International, judicial corruption in India is attributable to factors such as delays in the disposal of cases, shortage of judges and complex procedures, all of which are exacerbated by a preponderance of new laws. Most disturbing is the fact that corruption has reached the highest judicial forum, that is Supreme Court of India. Some notable cases include, in December 2009, noted social activist, campaigner for judicial accountability and a Supreme Court lawyer Prashant Bhushan, in response to the notice of contempt issued by the Supreme Court, filed an affidavit standing by his earlier comments saying, "It is my honest and bona fide perception." Later in September 2010, he submitted a supplementary affidavit in which he submitted evidence to back his allegations. In November 2010, former Law Minister, Shanti Bhushan echoed Prashant Bhushan's claim saying, "It is my firm belief that there is a lot of corruption in judiciary. I am saying the same thing which Prashant Bhushan had said. The question of apology does not arise. I will rather prefer to go to jail. The judiciary cannot be cleansed unless the matter is brought into the public domain." In June 2011, a very widely respected former Chief Justice of India J.S. Verma echoed these views, saying that certain individuals with doubtful integrity were elevated within the higher judiciary. He cited the case of Justice M.M. Punchy, whose impeachment had been sought by the Campaign for Judicial Accountability. Justice Verma said he was willing to permit the allegations to be probed, but the political executive refused to allow this. Justice Verma further explained, because the allegations, if proved, were serious and therefore they required to be investigated, so that one could know whether they were true or not. He acknowledged that Justice Punchy was later elevated to CJI despite facing serious allegations. Justice Verma also talked about another former CJI K.G. Balakrishnan's continuance as National Human Rights Commission chairman. Justice Verma said, "He should have demitted long back, and if he doesn't do it voluntarily, the government should persuade him to do that, otherwise, proceed to do whatever can be done to see that he demits office." In November 2011, a former Supreme Court Justice Ruma Pal slammed the higher judiciary for what she called the 7 sins. She listed the sins as, turning a blind eye to the injudicious conduct of a colleague, hypocrisy the complete distortion of the norm of judicial independence, secrecy the fact that no aspect of judicial conduct including the appointment of judges to the High and Supreme Court is transparent, plagiarism and prolixity meaning that very often SC judges lift whole passages from earlier decisions by their predecessors and do not acknowledge this and use long-winded, verbose language, self-arrogance wherein the higher judiciary has claimed crass superiority and independence to mask their own indiscipline and transgression of norms and procedures, professional arrogance whereby judges do not do their homework and arrive at decisions of grave importance ignoring precedent or judicial principle, nepotism wherein favors are sought and dispensed by some judges for gratification of varying manner. In 2011, Sumitra Sen, former judge at the Kolkata High Court, became the first judge in the India to be impeached by the Rajya Sabha for misappropriation of funds. Reform, E-Courts Mission Mode Project. The E-Courts project was established in the year 2005. According to the project, all the courts including taluk courts will get computerized. As per the project in 2008, all the district courts were initialized under the project. In 2010, all the district court were computerized. The entry of backlog cases started. The IT department had one system officer and two system assistants in each court. They initiated the services in the Supreme Court in June 2011. The case lists and the judgments of most district courts are available in http://lobisnik.in. In http, Judicial is used to connect all High Courts and Supreme Court judgments and cause list. These websites are updated daily by a technical team. Now the establishment work is going on tilak courts. The project also includes producing witnesses through video conferencing. Filing cases, proceedings, and all other details will be in computers. Each district court contains one system officer and two system assistants. This technical manpower is involved in training the staff, updating websites. Establishment of e-courts in India is in infancy stage. Till the month of August 2014 we are still waiting for the establishment of first e-court of India. Judicial Service Centre, this is a part of e-court project. The Judicial Service Centres are available in all court campus. The public as well as the advocates can walk in directly and ask for the case status, stage and next hearing dates. This service is provided for free. History, jury trial. The first jury trial decided by an English jury in India happened in Madras in 1665, for which a censure Dawes was charged by a grand jury with the murder of her slave girl, and a petty jury, with 6 Englishmen and 6 Portuguese, found her not guilty. With the development of the East India Company Empire in India, the jury system was implemented inside a dual system of courts. In presidency towns, there were crown courts and in criminal cases juries had to judge British and European people and in some cases Indian people. And in the territories outside the presidency towns, there were company courts without jury to judge most of the cases implying indigenous people. After the Crown Government of India adopted the Indian Penal Code and the Indian Code of Criminal Procedure, the criminal jury was obligatory only in the high courts of the presidency towns. Elsewhere, it was optional and rarely used. According sections 274 and 275 of the Code of Criminal Procedure, the jury was composed from 3 to 9 men. And when the accused were European or American, at least half of the jurors had to be European or American men. The jury found no place in the 1950 Indian Constitution, and it was ignored in many Indian states. The Law Commission recommended its abolition in 1958 in its 14th report. Jury trials were abolished in India by a very discreet process during the 1960s, finishing with the 1973 Code of Criminal Procedure, which is still enforced today. It has been argued that the 8-1 acquittal of cause Nanavati in K.M. Nanavati v. State of Maharashtra, which was overturned by higher courts on the grounds that the jury was misled by the presiding judge and was susceptible to media and public influence, was the reason. A study by Elizabeth Kulski argues that many perverse verdicts were delivered by white juries in trial of European British subjects charged with murder, assault, confinement of Indians. See also, Indian law, Supreme Court of India. Further reading, judicial delay may become a thing of the past, National Policy and Action Plan for Implementation of IT in the Indian Judiciary. Has India failed because of its judicial system? Judiciary in India Euro victim or culprit? Access to justice for marginalised people in India, use of software can curb bench hunting in India and increase disposal of cases up to 25%. Practice directions for electronic filing in the High Court of Delhi, e-courts in India still a distant dream, references.